Hope everyone is having a good day. So today we will continue with topic 5. Topic 5 on digital freedom of expression. So share screen. All right. Okay.
Sir, sorry to interrupt, but aren't we going to present first?
All of your group members are here?
Yeah, I think all of us are here.
Boleh juga you present dulu. Tapi saya dah buka dah ni. Is it okay if after my lecture ni, I'll take around maybe about 1 hour plus. So you can present. Boleh?
I think one of our members are not available at 9.
Okay.
So we have to present first.
Where would that person be going at 9?
Sir, I'm sorry, but at night I have a fixed consultation.
Apa tu? Consultation?
Consultation, yes.
With?
With Prof. Gofu.
Prof apa? Sorry?
Prof. Abdul Gofu.
That's on a different subject, is it?
Yes, sir.
Awak tak boleh buat consultation time lain. And then the whole class has to be arranged to follow your arrangement, is it? Okay, tak apalah. The group 4, is it group 4 or group 5?
Group 5, sir.
Group 5 kan? Okay, group 5 can proceed lah.
Okay, I'll present the slide.
Assalamualaikum everyone. Am I audible? Alright, so Assalamualaikum warahmatullahi wabarakatuh. My name is Adi Imani. Today we are group 5. Me and my friends Balkis, Mariam Jamila, Najla Alisha, Nur Aina and Wan Mashita will be presenting on the case of public prosecutor against Azrar bin Achoy, the case of 2018. Next slide please. So in this case review, we're going to present on the background of the case, material facts, legal issues, counsel arguments, the judgment, and rational standard. And lastly, we will be commenting and analyzing this case. Next slide. So for the background information of this case, this was a High Court case. It was held in High Court Kota Kinabalu, judged by the Leonard Rabindran, and it was decided on March 26th of 2018, and it is a criminal case which regards to terrorism. Next slide, please. So for the material facts, next slide. First of all, there was a police raid. The police raided the accused house after obtaining information that he was involved in security offences, but At that time, no one was discovered. Later on, the accused self-surrendered himself at the police station, where the police officer, plaintiff personal witness 3, arrested the accused after he surrendered himself to the police station. And next, the accused was associated with the terrorist group IS, where the police conducted a research and a mobile phone was discovered, and on that phone it was found some images and Facebook account that are promoting terrorism. And lastly, the prosecution established prima facie case where the accused was called to answer to his defense, which the defenses are: firstly, he did not agree with terrorism. He does not have exclusive use of the phone that I mentioned earlier, and including the Facebook account that he claimed that he was not the account owner. Next slide, please. So for the legal issues, next slide. There will be two issues that we will discuss. Firstly, which is whether accused defense is probable, and that whether reasonable doubt is raised on the prosecution's case. Next will be presented by my friend. Thank you.
All right, so I will continue with the counsel's argument. Next slide, please. For the case of the prosecution, a total of 11 witnesses has been called to prove its case. Firstly, on 27 June 2016, PW1, which is DSP Sufyan bin Ali of Counter-Terrorism Unit of Federal Police Headquarters, received the information that the accused was involved in committing security offences. Then, on 19 July, PW2 ASP Alizan bin Haji Dalaman of the Sabah Police Headquarters led a raiding party to the village. Did not find anyone in the house. Then, on 21st July, the accused surrendered himself at the Kota Belud police station and was then promptly arrested by PW3, which is Inspector Muhammad Hainal bin Zainal. Then, Inspector Muhammad Hainal also brought the accused to his house and made a search. He seized some items, including books, a Sony Ericsson handphone, and also a pen drive. However, these items did not incriminate the accused, and thus they are not the subject matter of the two charges. But then, according to PW7, which is the mother of the accused, who also testified for the prosecution, she mentioned that the Sony Ericsson handphone that the police took from her house belonged to her nephew. Next slide, please. All right. However, on 24th July, PW7, the accused mother, they found a Samsung handphone in the room of the accused and then handed it over to the police. Next, PW8, Inspector Nuzahirah binti Mustafa, who is a computer forensic investigator, extracted 72 images from the Samsung handphone for further analysis, but she was unable to extract anything from the Sony Ericsson handphone as the handphone was damaged. PW10, Professor Rohan Kumar Gunaratna, who is an academic researcher on terrorist groups, including the terrorist group that called itself as Islamic State, analyzed the said images, and he said that 43 out of 72 images are associated with Islamic State. So upon arrest, basically the accused provided the police with a password to a Facebook account by the name of Yohyo Ila Nun Al Sabah Malaysia. Then Professor Rohan basically analysed the postings on this Facebook account, and he concluded that they support the terrorist group known as Islamic State and promote terrorism as well. Next slide, please. Then PW6, which is Hairul Anwar bin Ma'nur, who is also a director at the Network Surveillance Department of the Malaysian Communication and Multimedia Commission, MCMC, gave evidence to link the mobile number of the accused to the Yohyo Ila Nun Al Sabah Malaysia Facebook account. At the same time, PW5, Muhammad Taufik bin Muhammad Zaki of the Selcom Axiata Sdn Bhd gave evidence of the status of the mobile phone number. He said that the mobile number that starts with 013 was registered under the name of the accused, which is Asroy bin Achoy, since 11 November 2015. So the postings in relation to the charges were made at the time the accused was the registered user of the mobile phone number. And it was contended that this were enough to prove that this was enough to convict the accused on the ground of the two charges mentioned. Next, please. Okay, so we'll move on to the accused defense. So firstly, the accused denied supporting the Islamic State IS. He said that he only knows about the Islamic State through watching news on television networks. He also viewed them as extremists, terrorists, and radicals. To a question by his own counsel, whether he agreed with their ideology, he said no. He reasoned that they are inhuman and deviant. He also mentioned that he did not do any research on Islamic State through the internet. And secondly, he said that he did not willfully sign the confessionary statements. So confessionary statements here refer to the statements in which he admitted posting messages applauding Islamic State on the Yuhyu Ila Nun Al Sabah Malaysia Facebook account. He said that he signed the statement because he could not withstand the pressure of being interrogated by the police and that he was very tired. Thirdly, he contended that he stated that he had no knowledge about the images in the phone. When it was put to him that therefore the images in the handphone had been put there with his knowledge, he said that his friend has also used his handphone. The accused then proceeded to name 5 of his alleged friends who had used his handphone. He also said that his cousin also used his phone. He named 4 of them. However, he agreed that they did not use the handphone every day. And lastly, he denied the knowledge of the Yuhyu Ila Nun Al Sabah Malaysia account. The accused agreed that the mobile telephone number that was used on the Samsung handphone was registered under his name. But in respect of the use of the social media platform called Facebook, he denied the knowledge of this account. He said that he is not the owner of the account and therefore he was not responsible for the postings on it. However, he do agree that the profile picture used on the said account page is his photograph. He also said that agreed that his photograph is also on the page 10 of the printout of the Facebook page that was tendered in the evidence. However, the accused basically denied being the owner of the Facebook account and said that he had his own Facebook account by the name of Azrul Samtasi. So I will pass on to the next presenter. Thank you.
Thank you. Next is about the judgment of the case. So the accused in this case was convicted of 2 charges and finally was charged with 2 charges and finally convicted under both charges. So under section 130J 1A of the Penal Code, which is about soliciting or giving support to terrorist groups or for the commission of terrorist acts, and 1A is about giving support to any terrorist group. And for the second charge, which is section 130JB, subsection 1A, is about possession, etc. of items associated with terrorist groups or terrorist acts. And 1A is when the accused has possession or custody or control of this item. And finally, the accused was found guilty on both charges, and the court ordered that he was sentenced to 7 years imprisonment for the first charge and 2 years imprisonment for the second charge. And both sentences were ordered to run concurrently. Next. So the recidenda of this case is based on 2 issues. Next. The first issue is whether the accused defense is probable. So as the defense used by the accused had only came up for the first time during the defense stage, the judge held that this defense was very likely a fabrication. So regarding the confessionary statement, the accused had at first said that his mobile phone had been used by his friends and cousins, but his mother had never told the police about this fact when she was handing over the phone to the police. Therefore, the accused did not, in his confessionary statement, the accused did not say about the alleged fact. Instead, he only said that during the defense stage. Secondly, is about the evidence of the phone being used by others. So the accused counsel had suggested that the accused did not have exclusive use of the phone, and this had been rejected by the courts. According to the accused mother, she only knew how to make and receive phone calls. So it was highly unlikely that anyone else could have used the accused phone. And further analysis had shown that there was no evidence of the phone being used by other people, even in the form of text messages. Next. Thirdly, is about the credibility of the investigating officer. In this case, the accused counsel had raised the suggestion that there was a break in the chain of evidence when the phone was sent by the investigating officer to the MCMC. But the court held that since there was no contradictory evidence to support the counsel's argument, therefore it must be presumed that the investigating officer was a neutral public officer and there was no reason for the court to doubt his credibility. And finally is about the absence of expert rebuttal evidence. The accused counsel had suggested that the images in question could have come from the phone's history folder when the users used the phone to surf the internet. However, a specialist who is also a police officer had verified that the images were downloaded and not automatically stored in the phone's folder history. Therefore, the judge held that since there was no expert rebuttal evidence from the accused counsel, so there was no reason to doubt the specialist evidence. I pass to my friend.
So for the second issue, whether reasonable doubt has been raised in the prosecution case. So reasonable doubt, as defined by Sharmaji in Public Prosecutor against Simon, it is a doubt in which makes you hesitate as to the correctness of the conclusion which you reach, and it is a doubt that arises from evidence or want of evidence and cannot be imaginary doubt or conjecture unrelated to the evidence. Next slide. So the accused was charged under 130J1A expressing support for Islamic State on Facebook account under the name of Yohyo Ilanen Al-Sabah Malaysia. So in this case, the accused only made a bare denial that he had knowledge about the account. Also denial of being the owner of the account and denied the expression support for the Islamic State as he disapproved the terrorist group. However, the accused did not provide any evidence to justify these denials. Meanwhile, there are 6 strong evidence that link the accused to the Facebook account, which are the accused mobile number was used to register the Facebook account and the account could be reset with the same mobile number. The password that the accused told the police can be used to access the Facebook account. The accused also cannot explain why his handphone was linked to the account and why he knew the password to the Facebook account. Also, it is not relevant that the accused had his own Facebook account named Azroy Santasi because a person can have more than one account on social media like Facebook. The accused also had put a picture with the mobile number on his Facebook page. And lastly, the accused mother mentioned that the accused family nickname is Yohyo. Next slide, please. So the court came to conclusion that the accused is the owner of Yohyo Ilanen Al-Sabah Malaysia FB account based on the evidence of the strong circumstances linking the accused to the Facebook account as mentioned earlier. So the prosecution can successfully rely on Section 114A of Evidence Act 1915 provides a rebuttable presumption that the accused was the publisher of the incriminatory posting. Next slide, please. So for the second charge, the accused denied knowledge of possessing the Samsung handphone. However, at this time, he had prevaricated the facts many times, and thus this strengthened the case of the prosecution. The defense that the phone is not his and had been used by many others are likely to be a fabrication, as nowadays it is not likely that one handphone has been shared and used by many others. Therefore, the accused failed to rebut the presumption in Section 114A of Evidence Act 1915. Next slide. So in conclusion, the defense of the accused was only one of bare denial, which will not be sufficient to cast doubt on the case of the prosecution. The court found the prosecution had proved its case beyond a reasonable doubt on both charges and therefore found him guilty upon both charges. I'll pass to the next presenters.
Right, next I will proceed on the comments and analysis. So we believe the accused to be guilty and we agree with the conviction by reason that the act of the accused is one of the form of radicalization, and we are of the view that radicalization via internet is a real threat against the security of a country and the government must prevent it at all costs. So radicalization is basically means that a process that involves either individuals or groups who have been indoctrinated into a belief that supports violent activities. In a research data by Research Institute Malaysian Youth Development, they found that internet is the driving factor on the spread of terrorism doctrine. There are a total of about 50% of media channels were used sourced from Facebook and 35% from YouTube. So we could see that from starting from the internet user could actually become a real terrorist and could actually impose a real danger towards the country. So for example, one of the implications that we could see in Malaysia is an event happened in March 2021 where the Malaysian police revealed that they had fought a ploy by an ISIS sympathizer to kill the Malaysian Prime Minister. In the same month, happened in Indonesia, 2 terrorist attacks within only 3 days, whereby first a suicide bombing at a cathedral in South Sulawesi and a gun attack on the police headquarters in Jakarta by IS-affiliated individuals. So this shows how much this issue is not to be taken lightly, and the government must impose strict restrictions in order to curb this issue. So what are the countermeasures taken by our government? So we could see that in our penal code, there is a special chapter specifically for offences relating to terrorism, and that is chapter 6A. And this is included under the threats to national security and citizens. Apart from the penal code, the government also introduced some other laws. One of them is Prevention of Terrorism Act 2015, or also known as POTA, and this is to prevent the commission or support for acts of terrorism involving terrorist organizations listed in foreign organizations. Next, we also have Security Offences Special Measures Act 2012, or also known as SOSMA. Its role is to act as a preventative measure by curbing terrorist activities from occurring and maintaining public order. So another issue that might arise is whether or not these restrictions or the laws are actually unconstitutional, because basically it restricts one's freedom of speech and association. So we do know that in our federal constitution, Article 10 provides freedom of speech, assembly and association. However, we must also take note that this article, these fundamental liberties is not absolute, as it comes with limitation. So we could see in Article 10 Clause 2, whereby it says that the Parliament may impose restrictions when it deems necessary when it comes to the interests of the security of the Federation. And so this is strengthened with the case of Public Prosecutor against Ui Kisai, where the judge quoted that the government has a right to preserve public peace and order, and therefore has a good right to prohibit the propagation of opinions which have a seditious tendency. So this concludes on how much it is important for the government to curb any issues related to terrorism. So I'll pass to Najla.
So the next comment that we wanted to put out is that we believe the accused to be guilty and we agree on the sentence that have been given by the court. In giving sentences, the judge must follow certain principles in awarding the amount of punishments, and those principles are retribution, the rehabilitation, and also deterrence. Retribution is preventing the future crime by removing the desire for personal avengement against the defendant. For rehabilitation, it is done by altering the defendant's behavior through educational and vocational program, treatment center, and also counseling. For deterrence, they cause fear towards the defendant or the public, for fear of the gravity of the punishment that had been given. So in chapter 6A of the Penal Code, which is about the offences of terrorism, some punishment that have been given is death sentence if the acts cause death. For imprisonment, there are 2. The first one, imprisonment for natural life, and also a fixed term of imprisonment. Next is fine and also forfeiture. But in this chapter, the interpretation have been given by us in section 130B subsection 1, whereby the imprisonment for life means that the imprisonment is until the death of the person that have been sentenced. Next. So the punishment that have been given in section 130J subsection 1A is imprisonment for life or imprisonment for a term not exceeding 30 years, and also with fine and also forfeiture of any property. Next. For section 130JB1A, the punishment that have been provided is imprisonment for a term of 7 years maximum, or with fine and also forfeiture. Next, please. Not only that, in deciding the sentences that would be given, the sentence could be consecutive sentence or a concurrent sentence. For example, if X faces 2 sentences for 2 years of theft and 3 years for criminal breach of trust, in consecutive sentence, it would the jail term would run one after the other. Therefore, after they have served 2 years for theft, next they have to serve another 3 years for criminal breach of trust. However, in concurrent sentence, the imprisonment would be done concurrently. Therefore, maximum imprisonment term would be 3 years. And the general principle is that if the convicted was sentenced for multiple or separate offences, it would run consecutively. However, the court would also be guided by principles in order to mitigate by looking at the terms of imprisonment, whether it's justified by the court or not. Next. So in this case, for giving the factors to mitigate the punishment, the defense counsel highlighted the accused's background, which is his educational and also economic background. The accused was educated up to Form 5 and he had failed his SPM examination. Then he worked as a pemetik buah kelapa. He also loved doing research on history, and he loves sharing information on social media, particularly Facebook. And he also decided to do a research on Islamic State because it always appears on news. So not only that, the defense counsel also said that he is naive and gullible, therefore he is misled by what he had read, and the support that he given to the terrorist group is only limited to online postings only. And not only that, the shared information, which includes the images, they share the information with friends by not realizing the sensitivity of the issue. And the accused only have 20 friends on his social media platform, and the accused was not convicted for any previous crime. Next. So in this case, the court have awarded him 7 years imprisonment for the first charge, 2 years imprisonment for the second charge, and the sentences were to be run concurrently from the date of the arrest. So in this case, the court highlighted that they should carefully consider the background facts of the offence and not merely look at the maximum punishment and consider whether the heavy sentence is appropriate. The provision provided in penal code only gives the maximum punishment, and the chapter of terrorist offence includes non-violent and also violent acts. So in this case, the accused had not committed any violent act and only provided material, information, and has not provided material assistance to the terrorist group or even had to plan to carry out terrorist attack. And next, one of the important aim of the modern criminal justice system is rehabilitation, so that the prisoner can return to society as a reformed person and not be a burden to the state. And the court highlighted that the prison department had a well-structured counseling program to aid the prisoners who had been influenced by the Islamic State in their reformation. The court also has a discretion to impose concurrent sentences if the offence are related, or if the imposition of the consecutive sentences would be disproportionate to the crime. Therefore, it is very justifiable that the imprisonment term is not that long and it is run concurrently. That is all from our group. Thank you.
Okay, thank you. Any questions? Any question?
No question, sir.
Any question from the group to the group? Okay. No question? Okay, thank you. Fandi, yeah.
Yeah, according to the judgment here, the punishment, I just want to clarify it. How the judge justify the heavy sentence for the punishment in this situation?
In this situation, because the provision only provided a general act of terrorism, it does not give any specific. It is a violent act or a non-violent act, and the provision also only give the maximum punishment. Therefore, the court in this case look at the facts of the case, whereby the accused only have done a non-violent act. So it is very not justified if the court would provide a much heavier sentence. I think 7 years is already long, so it is very justifiable through the nature of the act that the accused have done. That's why. Does that answer the question?
Yeah, but I just curious here why the court looks at the influence by the Islamic State in this reformation.
Why did the court look at the influence of Islamic State in this case?
Yes.
Because the accused only provided information on Islamic State. That's why they look at the influence of Islamic State. Because if the accused have also provide information on other terrorist society, then the DPP would bring in more witnesses to have their insight on the influence of the other terrorist attack. So in this case, because the accused only shared about Islamic State, therefore it is only the court only needed to look at that view only. That's why.
Right. Thank you.
Okay, thank you. Let's move on to topic 5. So in the previous this discussion, we talked about some of the ways in which the internet can be regulated, particularly content. It can be regulated through, meaning especially when the trend is that more and more illegal and harmful content have been found online. So governments are very much concerned about the availability of this, and especially when these risky content were made accessible to children, this becomes a problem for the society. So therefore, certain technical as well as legal measures, I think technical and administrative measures like using a filter, notice and take down, have been developed to as at least as a measure to limit the accessibility. But as we know that although with these mechanisms, these illegal and harmful materials are still there, in which why some countries like Malaysia, we advise the internet users that self-regulation is the way forward. So self-regulation, I mean, certain advisory or principles which is in line with our law and our culture has been developed, like content code, which is consolidated into the CMA. So we know that there are some sets of principles that if we follow this, then our cyber experience should be safe, and we can reduce this risk. So following that, this next topic will talk about the right to freedom of expression in the digital sense. In this topic, it does not intend to repeat whatever that has been discussed in constitutional law, but we want to see, as far as the digital element is concerned, how does the law corresponds to this freedom of expression or freedom of speech, so to put it, and whether the courts have been, what is the attitude of the court in taking into or in evaluating this right as our communication has started to transfer or transcend online. So is it similar, the right to free speech that we used to enjoy through the traditional media or through the real face-to-face conversation, is when the right is being exercised on the online platform like social media, like forums and so on? Does the court or the law treat the freedom of speech similar, the protection or the restriction similar, or is it the protection is much more stringent? The restriction is much more stringent as compared to the real one. So we, in this topic, I think this you can also, as you go along this topic, you should refer to chapter 2 of the Internet Content Regulation book. Chapter 2 has outlined the detailed discussion on this. So I'll be going through in principle, highlighting some important keynotes. So I think as far as the brief history is concerned, it's not just free speech originated as early as Greek. Tapi if we try to compare with Islam, there is a discussion on Islam later. Islam also, as early as the time when Prophet, we can recall that Islam has recognized the right to free speech much earlier than all these civilizations, all these Greek or whatever civilization. Tapi it was said that this part of the world where in this Greek civilizations morning, they have it marked the beginning of the legal system whereby the rights of people, especially Englishmen at that time, was somehow they were denied of their rights, in which this causes a lot of political as well as administrative problems at the time in England, very old time, 1215. So when there was very poor governance from the king level up to the ground, then rebels were taking chances, trying to to obtain to get control over the country. So in which it led to the signing of Magna Carta. Magna Carta, which is it is said that this is the first constitution in the world that recognize the rights of free speech and many other human rights. So when people talk about human rights, Magna Carta is they are saying that this is the first document that recognize the rule of law above any other powers of the king and so on. But we know that as Muslims, we know that for a fact that Al-Quran and the earlier revelations have long recognized the right to free speech. This can be embedded. We can see macam the establishment of Shura and so on. These are some examples that we can actually find. So we will see through this video. Maybe I think ada masa kita tengok sekejap. This video basically will illustrate the how the Magna Carta started. Meaning this was during the time in England and the civilizations surrounding it. So from a very they are having really bad governance because of due to the king's poor governance and so on, and as well as unfair policies. From there, they have managed to come together and agree to, this is political. They agree to come and sign this Magna Carta. From Magna Carta it further international law documents like the Universal Declaration of Human Rights and so on were expounded and were developed. So this it was also said that the right to free speech found its starting point from this Magna Carta. So I don't want to go into too much depth into this. Tapi I think this video can simplify the story lah, kan. Okay, kejap. If I play this, you all dengar tak? Cuba, can you?
Boleh.
Play, dengar?
Yes.
Alright.
It's the 15th of June, 1215. This is King John of England, and he's been cornered by all of these angry barons.
I'm so angry.
Me too.
These barons are angry because they are fed up with King John's unfair, but hold on, we're getting ahead of ourselves. Let's back up. Whoa, hey, that's a bit too far. That's more like it. Here's medieval England. And in medieval England, society was organized under the feudal system. At the bottom were the peasants. They farmed land that they had rented from the barons.
No money.
The barons were wealthy because they'd done a favor for the king, who'd given them land as a reward. At the top was the king. He owned everything in the kingdom and could do as he pleased, including making people pay tax.
I hate that.
So unfair.
A king's power was based on the belief, supported by the Pope and the Archbishop of Canterbury, that God himself had made the king the king. A king's power also depended on the size of his empire. If anyone understood this, it was Henry Plantagenet. He set out to make a massive empire. He inherited some land in France, but he wanted more. The province of Aquitaine in the southwest of France belonged to Eleanor.
Behind every good king is a lady with a lot of land.
When Henry married her, his domain grew by leaps and bounds. And then, when he became King of England, his empire grew again. So did his family. Henry and Eleanor had 8 children: William, Henry, Matilda, Richard, Geoffrey, Eleanor, John, and the final one was John. Poor John. As the youngest son, it was unlikely that he'd ever be king. But fate has a way of changing everything. When Henry II died, Richard became King of England. Richard spent barely any time in England. He was off fighting the Crusades or battling rebels in France. In 1199, while trying to take a castle in Charloux, Richard was wounded and died. So despite the odds, John was crowned King of England.
Hello, peasants.
Not only did John inherit a really big crown, he also inherited a lot of worries. Number 1, he needed to expand and protect his father's empire. Number 2, King Philip II was a huge threat to John's empire in France. Plus, he wanted to invade England and install his son, Prince Louis, as king. Number 3, Pope Innocent III wanted to appoint Stephen Langton as Archbishop of Canterbury. King John wanted to appoint his own archbishop. So the Pope forbade everyone in England from holding religious ceremonies for 5 years. The argument ended when John got scared that Philip was planning an invasion. John needed the Pope's help to stop Philip's invasion, so he paid a massive tribute. All was forgiven, literally. And Stephen Langton became Archbishop of Canterbury. And finally, John had to worry about the barons. He needed their support.
I've had quite enough of this. The king wants far too much money.
But the barons were fed up. In 15 years, King John had lost almost all of his dad's land in France, and it treated his barons very badly. In July 1214, he decided to attack Bouvines and lost. That's when the rebel barons started plotting.
The king is hiring an army.
We need to
He's
do
preparing
something.
for a civil war. Let's meet with him. Let's confront him.
They tried meeting with King John, renouncing their allegiance, even capturing London. But again and again, John ignored them. The rebel barons even considered asking Prince Louis to become king.
Bonjour.
This got King John's attention. And in June 1215, the rebel barons arranged to meet him in neutral territory, Runnymede.
You have no choice.
King John had no choice. He accepted the barons' demands and put his royal seal on the Charter of Liberties. He pretended to go along with it, secretly asked the Pope to do something. Then he waited in Dover for a response. Meanwhile, scribes made copies of the charter and sent them across the kingdom. Rebel barons also took possession of some of John's castles, including Rochester Castle in Kent. In September, a letter arrived from the Pope.
We, on behalf of Almighty God, utterly reject and condemn this settlement. We order that the charter be null and void of all validity forever.
But this did absolutely nothing to change the rebel barons' minds. So John started a rampage across England.
Es means war.
First, Rochester. He destroyed Rochester Bridge, then attacked the castle. After 7 weeks, the barons surrendered.
I will show him.
Meanwhile, Louis arrived in London. The barons swore allegiance to him. Now the only thing standing between Louis and the throne of England was the head wearing the crown. In October, John hurried towards Lincoln. He started feeling unwell. In his haste, he crossed the Wash before the tide had gone out. His baggage train got stuck in quicksand. All his treasures were lost. By trying so desperately to hold on to the crown of England, he somehow lost it to the sea. John got as far as Newark, broke, alone, and sick with dysentery.
I feel so sick.
King John died. So then John's son Henry became king. He had to be crowned with a plain gold ring.
Hello there, I'm King Henry.
The fact is, the English barons preferred a boy king over a French one.
What? But I thought I was going to be the king.
Au revoir, Louis. Bye. Ciao, ciao.
Especially since they would be in a position to advise him. Still, the country was a mess. So William Marshall, Henry III's main advisor and regent, reissued the Charter of Liberties as a royal charter to assure rebel barons that the new king would keep their demands.
We've removed the really troublesome clauses.
It didn't quite do the trick. So in 1217, William Marshall reissued it for Henry as part of the peace treaty to end the Civil War.
So how did the Charter of Liberties become Magna Carta?
When the charter was reissued in 1217, it had a second part, the Charter of the Forest. The Charter of Liberties was on a bigger sheet of vellum, and so it became the Great Charter. In Latin, that's Magna Carta. And that's what we've all called it ever since. In 1225, Henry III needed to raise taxes.
No new taxes! No new taxes!
Which raised a few eyebrows. So to prevent another rebellion, he reissued Magna Carta again.
I issue this Magna Carta of my own free will.
In 1297, Henry's son, Edward I, had the same problem.
I need more money to fight the Scots and the Welsh and the French.
And the same solution. This Magna Carta was entered into the statute rolls as English law, which meant that if a king wanted to change it, he had to get it approved by Parliament.
What's the big deal about Magna Carta anyway?
Well, in England, Magna Carta was the first step towards building a fair society where everyone has equal rights and nobody is more powerful than the law. This is the root of our legal system and government. Magna Carta and the English legal system became a model for other countries, including the USA.
Thank you, Magna Carta.
Australia.
Thanks a lot, Magna Carta.
New Zealand.
Cheers, Magna Carta.
Canada.
Thanks, Magna Carta.
And India.
Thanks, Magna Carta.
To name just a few. In fact, if our calculations are correct, 1/4 of the people in the world live in a country where the system of government was inspired by Magna Carta. And Magna Carta has inspired the idea that all humans everywhere deserve equal rights and freedom. After the Second World War, the United Nations decided to do something to protect the rights of everyone on the planet. Eleanor Roosevelt and her team wrote the Universal Declaration of Human Rights, which was approved in December 1948. She described it as
a Magna Carta for all mankind.
After that, countries around the world made their own laws to protect human rights.
Is that where the story ends?
Not by a long shot. Magna Carta was only the first stepping stone on our journey to a fair and just society. Over the past 8 centuries, all sorts of people all over the world have been inspired by Magna Carta to live lives, make laws, build countries that celebrate the idea that everyone is equal under the law. It's a remarkable legacy that's been passed on to us. We are all responsible for making our society fairer and more just. We are all responsible for protecting human rights. And now that you know the story of Magna Carta, it's your responsibility too.
Okay. So the one that you saw just now was we can say that that was the modern history of constitution around the world. If we try to track back, but as far as Malaysia is concerned, meaning we can see that there are some influences from these old documents. Not just that but also if we read the history of Malaysian legal system, as we have learned earlier on, we can see that our constitution is very much influenced not just by the Western, the English constitutions, but also Islam and many other factors that influence our development. So as far as free speech is concerned, we can basically trace the right to free speech as early as 1957. Particularly, it's written in the Reid Commission report. So in the Reid Commission report, it was, if you still remember, when we were about to obtain our independence. So Reid Commission went throughout Malaysia and then try to collect the opinion of the public on what should be the fundamental rights that should be there in the new Malaysian Constitution. So in this report, it was found that Reid Commission thinks that freedom of speech and expression is something that should be guaranteed to all citizens. So because of this, we have the provision on freedom of speech and expression that is embedded in Article 10 of Federal Constitution. But if you try to look at freedom of expression under Article 10, you will not find any word that says this right shall apply through any medium, through any sort of intermediary or medium that can be interpreted to include the internet. So we can simply read the provision and understand that the provision grants freedom of expression, freedom of speech to the people, but we cannot say that this freedom include any other medium, whether it's print, whether it's online, and so on. And if we look at the international law, for example, like Universal Declaration of Human Rights, the ICCPR, they specifically say that these rights include any other mediums of communication and so on. So what does that mean? Whether Malaysian Constitution recognize this right, but at the same time, they don't want to. Meaning, it can mean two things. First, it didn't spell out clearly that it applies to all medium. Maybe because it applies regardless of whatever medium. And as time goes by, there are many other technology that will come. So, in principle, as long as the freedom to speak is there, then regardless of whatever medium, the freedom should be available to the citizens in line with whatever law yang at the moment that we have lah. But the second interpretation that we can make is people can also say that the right may not apply because ini second interpretation, but I think least favorite interpretation lah. But we can actually see, as far as the courts are concerned, the courts do not trouble itself by thinking or going along the line of whether our Article 10 applies to the internet or not. So the court simply absorb the understanding that this is the right to free speech, and regardless of whatever medium, the freedom should be there. Of course, guided by the law lah, kan? So as far as definition is concerned, we can find many definitions. One of them is we can see here macam ni. Paul, for example, defined free speech as natural right of every man to self-expression. Yeah, we can also see another definition from Justice Sultan Azlan Shah in the case of PP against Oi. His Lordship said this in his judgment then in the 1971 case. The right to freedom of speech is simply the right to which everyone has to say, write, or publish what he pleases, so long as he does not commit a breach of the law. If he says or publishes anything expressive of a seditious tendency, he is guilty of sedition, and the government has the right to preserve public peace and order, and has a good right to prohibit the propagation of opinions which have seditious tendency. So, and another example given by Ahmad Masum here, the right to free speech does not only amount to or is restricted to speech, the words of mouth, but can also be extended to signs, symbols, and gestures. This is why sometimes music has been said to be one of the way to express your feeling or your opinion. Music, wearing of T-shirt that has some symbols or some wording that kan sekarang orang suka kan beli T-shirt, lepas tu macam-macam lah letak dekat T-shirt tu, and we have somehow especially banyaklah our people, we are very much supportive of the Palestinian cause to fight for the people of Palestinian. Sometimes there are these T-shirt that say something about the situation in there, only that kita macam tak perasan tau that what we are writing is actually sensitive issues that the people over there might get angry lah over. Tapi these are the things that we need to be careful lah, because this is also another form of expression lah. Yeah. Okay, so free in itself is vague. Yeah, this was decided in James and Commonwealth of Australia. But free speech does not mean free speech. It means that speech hedged in by all the laws against defamation. So it means that freedom governed by law, meaning we should not be confused with the idea of freedom. Even with freedom, it comes with responsibility. You have to, meaning that the government can enact law to restrict our right to free speech, to protect certain objectives, certain agenda of the country, maybe to prevent people from spreading defamatory remarks, sedition, and so on. So laws were created to provide as a break to the freedom lah. So freedom is like trains moving very fast, and then if you don't have brakes, it might cause accidents, isn't it? So this is the I would say some example lah. So taking this into consideration, House of Lords has established of what we can call as rule of thumb. So freedom itself is vague. So in order for you to exercise this freedom effectively, you need to refer to local circumstances, which is necessary to determine the scope of freedom. So restriction to freedom of expression must constantly conform to local circumstances where it applies. So as far as Malaysian internet users are concerned, our netizens should exercise digital expression in conformity with moral, religious, and ethical values of the Malaysian society. So this is the framework that self-regulation has been trying to promote here, and we can also see that this is embedded in the principles of the Content Code, whereby the idea that Section 233 and 211 of CMA has been elaborated in much greater detail. What are the things that our content should promote? What are the content that we should avoid, and so on. So this reflects our moral religious teachings in our country. Yeah. So as far as the meaning of digital freedom of expression, it's freedom of expression, but you do this through electronic intermediary over the internet lah. So that's the general idea, meaning that we recognize this freedom of expression, but this is done through online medium like news portal, online forum, online chat room, social media, and so on. And then you use a computer, laptop, notebook, Android or smartphone, which should not prevent you from expressing your opinion. But of course, digital freedom of expression should be exercised within the ambit of Article 10 of the Federal Constitution. Yeah. Okay, so Article 10, I think you have also learned Article 10 throughout maybe in Consti class previously, and in this topic we will dig a little bit further on this element of Article 10 and what are the recognition, what are the restriction, and we can also see that these are made in line with the international law. Yeah? Okay, so on the recognition and protection of freedom of expression, this is something that is very important towards developing a modern information society. So in an information society, of course, knowledge is power, knowledge is gold. Yeah. So freedom of expression, it becomes an enabler for citizens to acquire knowledge. So from an industrial society, we have moved into information society, and then it is said that now we are in a network society where knowledge and network is key towards development. So we can see that Article 10 guarantee the citizens' right to enjoy freedom of speech and expression. I think briefly on this, we can see that as far as Universal Declaration of Human Rights, we can see that Article 19, for example, the freedom of expression has been recognized under Article 19 of UDHR Similarly, under ICCPR, in the International Covenant on Civil and Political Rights, this is also has been agreed to be adopted by the United Nations, in which it strengthens the protection of freedom of speech under Article 9 UDHR. And we can see that in ICCPR, the medium is expanded. Yeah? It is extended to include the internet and any other medium that may come after the internet. Yeah? And also the European Convention on Human Rights also recognize the right to digital freedom of expression, yeah, by virtue of its Article 10. So as I said earlier, that the freedom of speech and expression is not just limited by in the form of word of mouth, but it can also be in the form of items, in the form of sound or gestures and many other ways to express our opinion. So there has been this case which comes to the court, of course not in Malaysia, but in France, LICRA and against Yahoo US, incorporated Yahoo US and Yahoo France, whereby at that time in France, they have made it an offense under the French Criminal Code to prohibit the wearing or exhibiting of public uniforms or insignias or emblems that resembles this Nazi punya items lah. So Yahoo ni dia ada satu macam listing, they are trying to do this auction. So there was this page on Yahoo that selling this Nazi punya items lah. So they found this and they try to NGO in French lah, they try to file a complaint against Yahoo US and Yahoo France in trying to ask them to take it down and refraining them from selling those items which were actually illegal under the domestic law of France. So in the year 2000, basically the claim by these two NGO in France was upheld by the High Court of Paris, and the court ordered Yahoo United States, the main Yahoo, to take all necessary measures to prevent access to auctions for Nazi memorabilia and any content supporting Nazism. So the court also ordered Yahoo France to warn users that should Yahoo results include content prohibited, under French law, they shall refrain from accessing such content. The thing is that here Yahoo US and France challenged the competence of Yahoo High Court in Paris, and also requested the court to reconsider its decision since compliance would be technologically impossible according to them. But after another round of hearing, the court reasserted its decision, and as a result, Yahoo has to comply with the decision. And from there, they have issued, they have amended the auction guideline. They have warned the user that sale of prohibited item which goes against the French criminal code is not allowed. So this is also another example of a case involved. It's a cyber issue, but involving two different jurisdictions, and we can see that the parties try to challenge the jurisdiction of the court, of a foreign court, but finally they abide by the order that has been issued. Perhaps one of them is because they have this branch in the country in France too. Yeah. So as far as free speech restrictions in Malaysia is concerned, we know that Article 10, Clause 2, it provides for the free restriction. Yeah. So Article 10, it allows it recognizes freedom of speech and expression. When it comes to Article 2A here, mana dia? We can see that it provides a certain kind of restriction that that acts as a guidance lah. What are the things that the Parliament has agreed to, so that these are the things that we declare as it is not freedom of speech. I mean, we restrict freedom of speech as far as these areas are concerned. So Article 4 of the Clause 2 of the Federal Constitution entrusted the Parliament as the guardian of freedom of expression in Malaysia. So meaning that any law that restricts freedom of expression in Malaysia shall be, meaning it will go through the Parliament. You have to make, a statute in order to restrict these kind of rights. The courts cannot question through judicial review the validity of any law which the Parliament under Article 10 Clause 2A has deemed necessary to pass, to impose restriction on freedom of speech. I'll share with you some decisions of courts that repeatedly mention this. So if any restriction to freedom of speech is not made in accordance with the requirement under Article 10 Clause 2, then the courts will have power to intervene. So it means now Article 10 Clause 2, it is the framework, the guiding framework in order for Parliament to pass law to restrict any kind of speech lah. So if the court is not empowered to tell the Parliament what should be necessary to be restricted and what should not be. So it is for the court to interpret the law as it is lah. So this position would practically make Parliament as the ultimate decision-making body in Malaysia. Contrary to the position in Indian Constitution, state may enact any law to restrict freedom of expression, and Indian courts may question the reasonableness of the restriction. So Malaysia maknanya as long as the Parliament make law that follows these requirements, the 9 requirements, the courts will not intervene or question whether this law is necessary or not. It's not within the scope of the court to argue. But if the Parliament make law that does not follow this restriction, this guideline, then the court may intervene. So what are the restrictions? Meaning in 10 Clause 2A, you can see that the parliaments can restrict our freedom of expression as far as these matters are concerned. If to protect national security, to ensure friendly relationship with neighboring countries, to maintain order of public, preservation of moral values, defamation, contempt of court, and so on. So it means that the parliament can make law, for example, to preserve, to protect against defamation. So Defamation Act was there to prevent, defamation from happening. It can happen, but at least meaning the law is there to stop you and to action can be taken against you. And in this situation, you cannot say that when you make defamatory remarks, you claim that this is your freedom of speech. So by this provision, the law restricts your right to defame someone, and this is made properly under the law lah. So maknanya kat sini action cannot be taken against people cannot claim that they can defame anyone. They can simply do contempt of court, and later they claim that this is my right to speak. So and so. So meaning that the law provides, although at the same, the law gives you some freedom, but the freedom is made or embedded together with some liability or responsibility or restriction, so to speak lah. Article 10 Clause 2A did not clarify who has the power to review restrictions which are necessary or expedient. So you can, if you see the wording of Article 10 Clause 2A, meaning Parliament has the restriction tu must be made for necessary or expedient reasons, and these are the some of the factors. Tapi in the Article 10 Clause 2A, it didn't say who has the power to review, to check, to review these restrictions lah. So in case of Madhavan, for example, the judge said that it is not within the competence of the courts to question the necessity or expediency of the legislative provision. And in another case, AG against Chiao, the court stated that the law may be harsh, but the role of the court is only to administer the law as it stands. So based on these decided cases, we can see that courts, it is not for the judiciary to decide whether a restriction to freedom of expression is necessary or expedient. The role of the court are confined to administer the law as it stands, although the law may be harsh in nature. So if any particular law is felt to be harsh, the platform to change that will be, you have to bring that back to the parliament, and the parliament has to quash, or parliament has to declare the or to invalidate the law. I think an example that we can see here is the Anti-Fake News Act, which was first fake news is another medium lah, another offense that we can say, okay, this is something that should not be allowed. So the government or the parliament decided to have a law to criminalize fake news. But then as time goes by, the parliament felt that the Anti-Fake News Act was maybe too broad, maybe needs further study and so on. So they repealed the law. And when it is repealed, the law is no longer there. But again, there are other laws to prevent fake news, but not specifically to that sense lah. So we'll come to fake news soon when we come to that topic. Yeah. So any restriction to freedom of expression that is deemed necessary or expedient by the parliament made under Article 2A cannot be subjected to judicial review. It cannot be subjected to judicial review. So this is my argument. Although we look at all these cases are traditional forms of expressions, meaning by way of traditional media. It remains vague whether Article 10 extends its application to internet, digital expression, due to the missing ingredient of whether they extend to any modes of communication. But we can see that courts are not troubled by this issue. The courts adapted quickly, and any new technology, the court took the spirit of Article 10. It means that we still have the freedom, but guided or being regulated by the law, the relevant law. If defamation applies, so we're not supposed to do defamation. So if any defamatory online comments happen, so action under defamation can be taken against. An example here, the case of Nur Hisham against PP. Sorry, I haven't translated this because I took it directly from the case report. Basically, the issue was about this Nur Hisham was indicted. He's being charged under Section 233 of the Communication and Multimedia Act for saying this indecent remarks on the page of Sultan of Perak, the official page of Sultan of Perak. He said these nasty words that I quoted there. So he was investigated and was prosecuted under Section 233. If you recall Section 233, this is about prohibition of publication of indecent content. So these issues were presented before the court. This case questioned whether Section 233 of CMA restricts the freedom of speech and expression that has been laid down or being granted under Article 10. So even issues like this was questioned in court. So according to the case, as the court examines the case, the court found that this restriction to free speech and expression through Section 233 is actually to ensure that you continue, you have your freedom to speak, but this is guided by the framework that has been allowed by Article 10 in the Federal Constitution, meaning it's freedom with responsibility. Yeah? So there's also this issue of whether Section 233 was constitutional, whether it follows the Constitution, and it was decided in this case that yes, it was something necessary, and it is made in line with the requirements of Article 10. And the court also looked at the case of Rasiah and Badan Peguam Malaysia, where the court gives this guideline. Yeah, the federal court gives a guideline in order to on how should we interpret the federal constitution. So the way or the method to interpret the provisions of federal constitution is to give a very wide interpretation. Yeah, and at the same time, if the provision talks about fundamental liberty, it must be generously interpreted. But when it talks about restriction to freedom, it has to be restrictively interpreted. So in a way, in this case, the court found that the word that was uttered in the Sultan Perak's page was something which is indecent, it is annoying to anyone who reads it, and this has no public benefit at all. So in this case, the appeal by the appellant in this case was dismissed. Yeah? So we can see that this case and as well as this case, Nik Adib, constantly they are trying to challenge the validity of Section 233. But the court has repeatedly said that this provision, as of now, it remains constitutional, and the restriction that is given under 233 is something which is in line with Article 10. So in Nik Adib Nikmat against PP, this is also another case that involves Section 233. Court of Appeal here viewed that cyber offences are serious offences, especially the offence concerning offensive material that could be easily disseminated to the public. So remember, court has made this observation where as far as cyber offences are concerned, court thinks that cyber offences are very serious offences, and because of that, it can influence the punishment. It can influence heavy punishment. So the court also say that here Section 233 is sufficiently important to justify the limiting of accused fundamental right to free speech, because it can harm public interest as well as defeating the objective of Article 10. So that's on the freedom of speech as far as online communication in Malaysia is concerned. And we can see that with freedom comes some restrictions, like, for example, Section 233 restricted our free speech, meaning that we cannot say anything which is indecent, obscene, menacing, or offensive as far as the digital media is concerned, and this has been limited by the provision of this CMA. On freedom of expression in Islam, we can see that many. This is the video that we watched earlier. Actually, Islam has recognized freedom of expression long before all this Western civilization. We can see, for example, Surah Ashura, verse 38. It encourages discussion or shura, where decisions are derived based on personal opinion. So many other examples in the Quran that clearly call for freedom of expression. For example, Prophet would listen to the advice of the companions, before arriving to a particular decisions and so on. Okay. Of course, with freedom of expression, Islam also recognize some restrictions, and this is, for example, sedition, fitnah, slander, qazaf. All these are has been made into the laws of Islam, whether through hudud, qazaf or ta'zir. So maknanya memang Islam has recognized this freedom of expression much earlier on, and it has been embedded into our the Quran, Sunnah, and so on. Okay, so as far as freedom, the right to freedom of expression in Malaysia, we see that the federal constitution recognize it, but at the same time, the right can be restricted. How to restrict the right? It is done through the parliament. Parliament make law which can restrict our freedom of speech. Some of which include defamation, fake news, and so on. The cases that we have seen just now try to challenge the validity of the law, but we can see that the court takes this view of it will interpret the law in question in line with the objectives of Article 10. So if that is the way, meaning it is free speech with responsibility. Okay, before I move on to these 3 examples of restrictions, whether there are any questions that comes to mind. Are there any questions? Ada? Okay. All right. So just to give you a little bit of examples of free speech restriction that was made through legislations. So these are some examples. For example, sedition. Sedition in Malay is known as hasutan. So the parliament has enacted this Sedition Act. Any speech with seditious tendency, including those which will bring into hatred or contempt, or to excite disaffection against the government, or engender feeling of ill will and hostility between different races, are said to form part of this definition of seditious tendency. So the meaning of seditious tendency is defined in Section 3 of Sedition Act. It's pretty similar to the English definition of sedition. Okay. So Section 4 specifies anyone who does or attempt to do any act which has this seditious tendency is guilty of sedition. So what are the examples of acts which can be defined as seditious tendency? Example is given under Section 3, Clause 1, A until F. If any acts which can be interpreted to bring into hatred or contempt or excite disaffection against the ruler or any government, excite the subjects of the ruler or the inhabitants of any territory, blah, 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 to bring into hatred or contempt or excite disaffection against administration of justice in Malaysia or any state, to raise discontent or disaffection among the subjects of the Agong or any ruler of any state, to promote the feeling of ill will and hostility between different races or classes of population in Malaysia. F, to question any matter, right, status, position, privilege, or sovereignty or prerogative established or to protect any rights under Article 152, 153 or 181 of the Federal Constitution. So if anyone is found to do these acts, meaning that they have, although you do this online, nowadays people have the tendency to commit this online. So the sedition, it can come under this provision. Example is case of PP against Kapal Singh. He was found to have uttered these words. Sorry, this one macam kecil sikit. These are the exact words that he uttered. It was somewhere in 2009. It was done in 2009. So these words were said to be it was made against the Sultan of Perak. If you still recall, 2009, 2010, there was this constitutional problem in the state of Perak. Ada some problems lah as far as the appointment of Menteri Besar is concerned. So some people were attacking the Sultan for some administrative decisions lah. So these remarks were made, dia kata Sultan Perak this has no power and this and that. So the accused was brought to the court, and it was in summary, it was found that there was a prima facie case established against the accused. So at this point of time, it was found that there was a case of sedition against the accused. Another example is Harith Fatilah against PP. This was also somewhere, it concerns political issues juga. They were caught, these people were calling for the transformation of the government, but there was this video recording whereby the accused was said to ask people to come to the turun ke jalan raya, and then untuk menghadapi musuh rakyat perlu menghadapi musuh di jalan raya. So this was said to be captured in a video recording, which was later the accused was charged under Sedition Act. So although the accused denied that the meaning of his speech was to incite people to go to the roads and to change the government, at the end of the trial, it was found that the accused was guilty for sedition, and then the accused appealed, but the appeal was allowed in part. But again, the decision here was that he was still guilty for sedition. Another case was Muhammad Safwan against PP. The crux or the principle of this case, I want you to take note. The court here said that as far as evaluating whether a particular statement or speech attracts seditious tendency, so this is a matter to be evaluated by the court on an objective basis. This is the test that the court has put forward. So tak kisahlah, doesn't matter it is done online, on the social media, or on any video. We can see macam in the case of Harith Fatilah, it's done in video, but similarly it attracts the same legal principle. So the court will have to evaluate on an objective basis. The court will have to take into account the natural meaning of the word or the words in the statement used. So to transcend into being a seditious statement, the court must find that it has crossed the boundaries of acceptable political comment permissible under the law, and it has transcended into the realm of sedition. So this, the court will have to evaluate the facts as a whole, and the court will have to come to a finding that it is no longer free speech. It has come to it is seditious words. So this has also been explained in PP against Oi. The court says this: a line must be drawn between the right to freedom of speech and sedition. In this country, the court draws the line. Who draws the line between which one is your right to speech, and when it comes to sedition, the court draws the line. So the court said that the dividing line between lawful criticisms of government and sedition is this. This is the exact wording. If upon reading this impugned speech as a whole, the court finds that it was intended to be a criticism of government policy or administration with a view to obtain its change or reform, the speech is safe. But if the court comes to the conclusion that the speech used naturally, clearly and indubitably has the tendency of stirring up hatred, contempt or disaffection against government, then it is caught within the band of Sedition Act lah, Section 3 Sedition Act. So this is meaning that if people are being charged for sedition, the court will have to come to this conclusion. Sometimes speeches like we can see in previous examples, there is a huge difference between making speeches with the view of giving constructive criticism as opposed to giving views with the objective of inciting hatred. So the words used are different, and this we leave it to the court has the final say to determine whether the speech has transcends into sedition. This one, Mark Cording, accused, was found guilty for sedition for asking the Federal Constitution to be amended by abolishing Article 152 on Malay language as the national language. This is clearly an offence under Section 3 as well. That's one. That's on sedition. The second example is on official secret. Official secret has been regulated under Official Secrets Act. Any document, I think we have listened to a case review last time on official secret. So any document, record or deliberation of government, usually the top meetings lah. If it is labeled as secret or confidential, then it is regulated under the OSA. Example is this PP against Subarau. This, if we still recall, our one of the group presented on this case. UPSR exam was leaked through smartphones, and it was found that after going through the case, it was found that yes, the UPSR examination paper were official secrets, and therefore the accused persons were found guilty. So, and the third example is parody. There has been a lot of debate on whether parody is a protected speech under the Constitution. Do you know what is a parody? Parody, example, a very famous example is the case of Fahmi Reza. A lot of parody has been made in the form of caricatures, trying to macam menyindir, trying to send a message, but it's not exactly defamatory or what, but in a way people can become angry after looking at the parody, or maybe people can become annoyed, and when this is done, especially when it relates to a public figure, sometimes it has some effects on the image and so on. So one of the famous people like Fahmi Reza has been making this clown caricature of the Prime Minister, the then Prime Minister Datuk Seri Najib Razak, and was charged under Section 233 of the CMA. So the accused basically argued that this so-called caricature was actually a parody and political satire to criticize the authorities for restricting freedom of expression online. So, however, the court, in this case, Justice Muhammad Razif, found that the notice is a fine and creative artistic work created by the accused to criticize the authorities. However, it is false in nature and was created with an intention to annoy a person. So the court was of the view that there is no need for the prosecution to prove that the accused annoyed the complainant, but there was just the mens rea was whether he intended to annoy annoy any person. So this is also an element under Section 233. So parody, again, at this point of time, the court has further observation here. The court also found that notice cannot be considered as a parody because it does not fall within the definition of parody set out in the case of this 2015 case of Sepakat Efektif against Menteri Dalam Negeri. So the court here say that the court say if a parody does not prickle, it doesn't work. The court also held that the notice, although it is an artistic work, but due to its nature of annoying another, it has no right to be displayed by the accused, and therefore the court found that it should not be protected under the pretext of freedom of speech. So the accused person was found guilty and sentenced accordingly. Okay, so as far as parody is concerned, we can actually think and analyze whether parody is allowed or not allowed in Malaysia, especially when it comes to digital medium nowadays. Again, it goes back to the principle. I think the principle that we look in the case of sedition earlier on. You really need to look at the content, whether the content annoys, whether it fits into any of the elements stated under the law. So if the law, like Section 233, prohibits dissemination of offensive content, and this is done, this is done with intention to annoy other people. So this is the framework that has been set by CMA, for example. So okay, you can do parody. Actually, you can do parody. You can draw whatever cartoon you like, but as long as it doesn't come into the prohibiting framework that the law has set, that should be fine. So buatlah whatever parody itu, but as long as it doesn't come into the elements of crime that has been put forward or has been there in the law, then it should be okay, regardless you do that on the internet or what lah. So that is the principle here. So we can be as creative as possible, but bear in mind that the freedom to be creative can also be limited by way of the law that has been passed through the parliament, meaning that we can enjoy some freedom of expression online, but let's say some of the work that we do is said to transgress the law. The judicial process or the legal process should take place to determine whether our work has infringed the law. And of course, if we were found, the court finds that our work has transgressed the law, then our speech can be restricted by virtue of that law. So that's the whole scenario. Okay, that's the end of this topic. So in summary, we can say that as far as the digital freedom of expression is concerned, in Malaysia as well as other countries here, we particularly in Malaysia, we can enjoy the freedom of speech online. We can write what we want. We can write diaries on our Facebook page or on our Instagram, whatever pictures we want to take. The picture of teh tarik ke apa ke kan, as your breakfast, you can take. But at the same time, the law recognizes this right of yours, but at the same time, the right has to be exercised with certain restrictions, so that it will not hurt others. It will not, it will not cause annoyance to others. So there has to be this balance in the exercise of digital freedom of speech. Okay, right? Any question? issues concerning sedition, parody. I think these are some relevant or hot issues now. People, especially being exercised through the digital media, there is this delicate balance. Sometimes when the parliament try to restrict your right to do anything online, sometimes people try to relate that with censorship. But remember that that will not be done if you stay within the framework of what is allowed under the law. So that's the difficult balance lah, kan? Which is why the court is being tasked to determine. Okay, the court must find whether the particular speech has transgressed into sedition or illegal speech lah. And okay, and no, any other question? Any question? Ada? Okay, if there's no question, inshallah we'll meet again on this coming Monday. This coming Monday at night at 8 p.m. Inshallah 8 p.m. We will have the replacement lecture. Just a reminder that on 26 Friday next week, 26 we will not be having a class. So saya replace that on the 22nd. So on the 22nd, which is next coming Monday night, we will discuss topic 6. Topic number 6. Thank you. Let's close with tasbih kafarah. Thank you. Assalamualaikum.
Waalaikumsalam. Thank you, Doctor.
Thank you, Doctor.